Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Well, welcome everyone, and we are very happy to be holding a session of the Court of Appeals at Campbell today, doing some of our Campbell alumni judges panels. We have two of them today because we have so many now, and so it's very exciting. So we're very happy to be here. Your panel for the first case, State v. Ducker. Myself, Judge Donna Stroud. To my right, we have Judge John Tyson. To my left, Judge Toby Hampson. And so we will, after our argument, we're going to take a few minutes just to, say a few things and introduce some people and whatever, but we will go ahead and start the argument. I understand that the appellant wanted to reserve 5 minutes for rebuttal. Okay. All right, we do not have our little fancy timer that we have at the Court of Appeals, so we have my phone and your phone, and so we'll try to keep up with it that way. And all right. We're ready to proceed.
May it please the court. Good afternoon, Your Honor. Jim Graham with the Office of the Appellate Defender. Seated with me at the council table today is our appellate Martin Birding, also a Campbell Law alum himself. It's our pleasure today to appear on behalf of Mr. Ducker. As the court mentioned, we're going to reserve 5 minutes of our time for rebuttal. And I want to come right to the heart of this case today, Your Honors. Despite the state's insistence in its brief that this has been settled by the United States Supreme Court, it should be evident to everyone at this point that it is not. Different jurisdictions around the country, including different federal circuits sitting on Hong Kong, have reached exactly opposite conclusions on some of the issues that are presented by this case. And for that reason, I think it's likely that the United States Supreme Court at some point in the next year or two is going to grant a petition in one of these felon in possession cases and perhaps give us a little more guidance. That said, this case is before the court now, and the court has to decide it, and I think in the form of Bruin and Rahimi, we have quite a bit of guidance already. And as I hope the briefing makes clear, which result the court reaches in this case may hinge in some measure on which of the two broad analytical approaches the court takes. And if I can summarize the first view, you have on the one hand an approach advanced by the state, which is, to be fair, some courts around the country have been seduced by, which is you take this hedging dicta in United States Supreme Court cases about how felon in possession statutes are lawfully, or presumptively lawful, and you elevate that to a constitutional command that they are always and everywhere lawful in all circumstances. And if you have to make that result fit into the text and history test propounded by Bruin by arguing that the people doesn't mean the people like it does everywhere else in the Constitution and the Bill of Rights, then so be it. That's the argument you have to make. That's one approach. And I think that one has some uncomfortable implications if the court thinks it through. On the other hand, you can take the approach of saying, okay, let's test whether these presumptively lawful felon in possession bans actually survive after you apply the history and text, the text and history test of Bruin. Let's see if those actually pass muster if you apply the actual analytical framework the United States Supreme Court has laid out. And when you do that analysis, when you actually do the analysis, when you don't just jump to, well, they're felons, we don't like them, they can't have guns, they're dangerous. When you actually do the analysis the United States Supreme Court has laid out, you have to come to the conclusion, at least in this case, that Mr. Ducker could not be prosecuted for simply carrying otherwise lawfully a gun in this case. The state fails to carry its burden to demonstrate that he is not a member of the people, and it even more, I think, obviously fails to meet its burden to establish that we have some grand historical tradition in this country of unilaterally, preemptively, and permanently disarming anyone who's ever been convicted of a crime we happen to call a felony, no matter how far in the past it was, no matter what the nature of that crime was, no matter the particular characteristics of the defendant. I don't think the Supreme Court allows for that, and given the lack of historical support for the state's position in this case, I think when that opinion comes out from the U.S. Supreme Court, it's going to look a lot more like that second approach I just laid out, our approach.
One of the things we have to deal with in this case is that the presumptively lawful language comes out of Heller and Bruen itself. It's not been overlaid on those decisions. It comes out of those decisions. So it is part and parcel of the United States Supreme Court precedent on these issues. So how are we to overcome what the Supreme Court has said?
Sure, Judge Hampson, and I think we've acknowledged in our briefing that there is at least a facial tension, right? The Supreme Court keeps sort of reiterating this dicta, but that dicta doesn't square with the actual analysis if you get into it. And this is not something that we have concocted now in 2025. This was noticed at the time Heller came out in 2009. There's that sort of throwaway line in Heller where Scalia says, nothing in our decision casts doubt on the long-standing prohibitions against allowing felons to possess guns. Well, it turns out, if you actually crack the books and do the history, Justice Scalia was one of the greatest jurists of the 20th century, or certainly one of the most consequential, but he was human, and he made a mistake. If you look at the actual historical breadth of regulation, these prohibitions are not long-standing. They're entirely creatures of the 20th century. So I recognize, Judge Hampton, that there is a tension between what the Supreme Court is sort of saying in the background in dicta in these cases, in Bruen and in Heller, and not being able to exactly square that to the analysis. And recognizing that tension, I think the court has an opportunity to say, well, what are we going to do? We're going to reach the politically expedient result based on this dicta, which is not essential to any of the holdings. And for that matter, the decisions that dicta come from also at the same time say, we're not doing an exhaustive survey of the contours of the Second Amendment. We're not saying that it's not this. The U.S. Supreme Court often does not like to decide more than it has to. And I think that's where all of this dicta in Heller and Bruen and Rahimi is coming from. They don't want to get out ahead of their skis and say, and for that reason, all of these laws are constitutional, all of these laws are unconstitutional.
How have the circuits that have agreed with you, how have they recognized or reconciled that tension between the, quote, dicta in Heller and arriving at a result that's consistent with your advocacy?
Sure. Well, they apply the actual Bruen and Heller and Rahimi tests, right? And I think it's important to note in those cases, none of those cases involve firearm by felony at all from the U.S. Supreme Court. That's why I think the U.S. Supreme Court is going to probably grant a petition to make sure we're on this. But none of those cases involve it, and the court is explicitly in those decisions saying, again and again, we are not undertaking an exhaustive review here of the law. We are not staking out the boundaries of where the Second Amendment right to keep and bear arms has historically been understood. That stuff is just in there. And I don't have a great explanation for why it's in there other than the court wants to maintain the legal status quo while it considers these issues. The problem is it's creating an analysis that if you actually follow through the implications, and I would ask the court to take a particular look at the Fourth Circuit decision, not the Fourth Circuit decision, the Third Circuit en banc decision in Range. Take a look at that decision. And then compare that to, say, the case that the state has provided in its memo of additional authority, which is Williams. And look at those two cases together. Actually, I want to talk about Williams in particular. So Williams is a case where the petitioner actually, in that case, lost. They said, we are not holding that there's any facial problem with these statutes. We are not, we're going to strictly apply an as-applied view to this. And after sort of surveying the history, the court actually, Williams, even though the defendant in that case, that particular case, loses, the court is saying a lot of stuff in this Williams decision that jives with essentially our argument in this case, right? That the text of the first, because I think we need to back up a little bit here, right? This is not a case where this is presumptively constitutional. right? This is not a normal constitutional case where the case law tut-tuts about, well, you know, enactment of the legislature is presumed constitutional or not. This is almost like a First Amendment overbreadth situation. If the plain text of the Second Amendment protects Mr. Duggar's conduct, then it's the state that bears the burden at that point of demonstrating to this court both, one, that he's not a member of the people, but two, that we also have a historical tradition that is at least somewhat analogous to this indiscriminate and preemptive disarmament that we have in the statute. And I don't think the state has met its burden on either of those prongs, except to point to this language in the U.S. Supreme Court decision to say, oh, well, this is all conclusively decided. Look at this, what they're saying in these cases. If the U.S. Supreme Court itself believed that this was as settled as it was, it wouldn't be behaving in the way it has been behaving recently with all of these cases that come up to it. In the wake of Rahimi, there were cases before the court, before the U.S. Supreme Court. This is all laid out in the reply briefing.
Including range.
Yeah, right.
When he was remanded.
Right. And then the en banc letter. And then the en banc Third Circuit said, even in light of Rahimi, and I agree with the en banc Third Circuit, even in light of Rahimi, there's no change in the analysis here. In fact, I think Rahimi is, in fact, helpful to our position because Rahimi shows, you know, sort of, if Heller says the Second Amendment is a thing and McDonald says it is incorporated against the state, and Bruin says here's generally the contours of the test, well, then Rahimi, the fourth case in that series, is the first one to actually apply the analytical framework. And in Rahimi, what the court is doing is very faithfully looking at the analytical framework and saying, okay, is Rahimi within the people? Clearly he is, right? He's an individual, he's within the meaning of the people. The people has been defined broadly in the case law. Okay, so do we have a historical tradition of disarming people in the manner in which Rahimi was disarmed in the 50B context? And the court said, yeah, let's look to the historical analogs and see, you know, sort of how we've handled similar problems, and it pointed to the surety laws and going on to the terror, up to the public laws to say, we have a history in this country of when we identify somebody who's dangerous, and a judge makes a finding of dangerousness, that we may disarm that person for a limited period of time consistent with the historical contours of the Second Amendment. Now, Rahimi loses in that case, but what separates Rahimi from Mr. Duggar and from similarly situated defendants as Mr. Duggar is that none of that is going on in this case. Nobody has found Mr. Duggar to be dangerous. He's not dangerous. He's just not. And no judge has made that finding. The thing that makes him dangerous is the fact that the crime for which he was convicted happens to be a felony.
Now, you're making two arguments. You're making a facial challenge and an as-applied challenge, correct?
Yes, Your Honor.
And when you look at what Justice Gorsuch in his concurrence of Rahimi, basically you would have the burden to show in a facial attack that the statute would violate the Second Amendment in, quote, all its applications.
Yeah.
You want to expound upon that, why you feel like that a facial challenge has any validity when the burden that you have under that standing?
Yeah, of course, Your Honor. I'd be happy to address that. So that is obviously correct. And in all candor, Your Honor, I don't think a federal court so far has found that 922G is unconstitutional facially. No court has found it.
Including the ones that agree with you.
Including the ones that agree with us, yeah. And now, that's our argument, I think, boils down to, the facial argument, at least our facial argument, boils down to the regime we have, right, does not comport with, it gets into difficult questions for this court of sort of where does it sever the line. And I think the concern, the reason why we've raised the facial challenge is we are extremely confident that Mr. Duggar is protected in this case. And that's all we need the court to decide, and that's all we're asking the court to decide. But I think there is a thing going on with the facial component in this case, whereby how does the court sort of, unless the court is going to commit to a practice whereby every defendant shows up at appellate court and goes, not me for reasons, then that's one thing. But if the court is not prepared to do that, then I think the facial argument needs to be addressed because although there is some hypothetical situation where somebody who has prior felonies can be disarmed, I don't think anyone is arguing against that proposition, Judge Tyson. There has to be some line drawing done, and the line we have drawn here by the General Assembly is just at too high a level to be constitutionally workable. So it sort of presents almost like a severability problem, I guess, Judge Tyson. I'm not really pounding the table here saying you must invalidate this statute in toto for every defendant in this state. I think the court may want to do that because this statute is just unconstitutional. But I understand the language you're citing, Judge Tyson, and I'm familiar with those cases about how in order to succeed in a facial appeal, every conceivable circumstance application. And I think it's touched in the briefing a little bit. That's a Gordian knot of precedents and things that I'm not sure I can fully address in context of this argument. But there's some discussion of it in the briefing in terms of where does the court want to draw this line, right? We just talked about Mr. Ducker, or are we saying, yeah, okay, well, we've fixed Mr. Ducker's issue in the statute, but now we have a statute that's going to be applied to 1 in 12 North Carolinians.
So let's talk about the as-applied challenge without,
Sure.
I just wanted to establish, that we have not yet seen a court, even those who are agreeing with your as-applied challenge, to hold a facial invalidity,
Correct.
even the ones that agree with you.
Yeah, fully stipulated, Judge Tyson.
So on the as-applied challenge, what sets your client apart from everyone else? As you said, not me.
Well, it's not perhaps everyone else. I think it's probably important to recognize, like I said, I think it's something like 1 in 12 Americans has a felony conviction, including the President of the United States. This is a big problem. So I don't want to narrow it necessarily to Mr. Ducker, because there will be another Mr. Ducker tomorrow and another Mr. Ducker tomorrow. But in this case, what separates Mr. Ducker is that if you actually apply the analysis of Rahimi and Bruin, you come to the conclusion that at least as applied to him, this is unconstitutional, and here's why. So the state has to demonstrate having the burden, because I think we should be able to agree that Mr. Ducker is one of the people. I know the state contests that. We'll probably have much to say about that. But Mr. Ducker is a member of the people the same way he's a member of the people under the Fourth and First Amendments. There's no court that has ever said that a person who is completely done with all of their punishment and is a felon, not somebody on parole, those rules are different, not somebody in prison, those are the people who are done or are a felon. There's no court, I don't think, that's ever said that person doesn't have a right to peaceably assemble or to address their government, protest their government for the redress of grievances, or that they don't have an expectation of privacy under the Fourth Amendment. I mean, the implications of the state's argument on that front should be a little concerning to the court, I think, particularly given the way that this offense is policed in our communities in a disproportionate way in some circumstances. So you start with the fact that Mr. Ducker is a member of the people. The state then has to demonstrate, okay, assuming he's a member of the people, do we have a historical tradition of something like this, right? Something, it doesn't have to be exact. The case law says that it doesn't have to be a historical twin. It just has to be something that looks kind of like what we do now, in a real way, not at a high level of generality, not at waving the wand and saying this person's dangerous so they can't have it on, but draw a real connection, like the court did in Rahimi, to the actual historical record that outlines the boundaries of this right. Because what we are, in essence, doing here is Scalia-inflected originalism and textualism. We want to understand what the scope of this right was at the time of the enactment. So we look to these historical analogs, not because we want to do history for the sake of history, or not to find some sort of justification for the politically expedient result, or whatever the result the court wants to reach, but because it's the only way to figure out what this right actually means in its origination. And so the state bears the burden of showing us the historical analogs. And, the reason why I think I've spent so much time up to this point emphasizing the weakness of the state's argument on the people aspect of the argument is because if the state has to convince you of that in order to win this case. Because once you get to the history tradition, the state was not able to produce very much of anything that looks like our system. That's not because the state doesn't have excellent lawyers, they do. Particularly in this case, it's because those analogs simply don't exist. Let's tick through them, right? The first thing the state says is, well, we have these colonial statutes from New Netherland and North Carolina where somebody accused of illegal hunting can have their firearm taken away. You know, respectfully, I think if the state were talking about something like asset forfeiture, they might, a modern concept like asset forfeiture, they'd have a point. But these statutes that they're citing in the hunting context don't bear any resemblance at all to the statute we're talking about today. They imposed a fine or the forfeiture of a firearm as criminal punishment for the violation of a firearm-related offense. It did not permanently ban that person from possessing guns. That person could go out the next day and buy a gun if they wanted to. Or at least that's what it appears from the historical documents that the state has provided.
When you talk about the permanence of this, obviously the possession of a firearm by a felon, it doesn't exist just in a vacuum. There's sort of a regime there which also provides, in certain instances, for the restoration of those rights.
But that is a 20-year in the future proposition under our law. So we're talking about restoration 2 decades in the future, which I can see the point a little, Judge Hampson, but I think that that's too sort of attenuated.
Which then gets to a broader question, which is, at what point is this an as-applies constitutional argument, and at what point is it simply a policy argument for narrowing the scope of these statutes by the legislature? So sometimes that line gets blurred.
Yeah, and that sort of dovetails with the point I'm making about this. Are we a facial or as applied in this case? That's kind of the difficulty that I'm trying to grapple with Judge Hampson. Because clearly there must be a regime where people who are in actual danger to others, who have demonstrated they're in actual danger to others, and will be danger in the future potentially to others, maybe disarmed. There's got to be a legislative regime where we can do that. I think any reasonable person would agree.
Do we consider just the original charge, or the fact that he had the violation of domestic violence protective order apparently twice later?
Well, we don't know anything about those DVPO violations.
Well, we know that it exists.
Sure, but if you make a phone call to somebody that's unwanted and you have a DVPO, that's a DVPO violation. That's sufficient
Right.
grounds to be. So, I don't think we can infer. It's sort of similar to what the state is doing and saying, well, he was convicted of attempted flee to elude, and
But
this was.
don't we really have to be able to just look at the crime that was convicted? I mean, without going back into history and examining the particular factual circumstances of every single thing a person may have been involved in?
Yeah, I agree.
We don't have to, a court sort of has to be able to look at, like, okay, you were convicted of this thing.
Yeah, I agree, Judge Stroud. I think that's a really difficult and probably unsuitable exercise for judges to be doing in every single case that comes before them, which is why I think the General Assembly probably has to do some line drawing to fix the statute.
And
This
you're
was not-
at about 4 minutes. I'll give you, we've asked you a lot of questions, but I just
Okay.
wanted to let you know
I
that.
have 21, is that right? 21 minutes in?
You're doing the math backwards. Yeah, okay.
Yes.
I can't do math in my head. That's what we should say. Anyway, yeah, that would translate to the same.
Okay.
Let me ask you this, the statute does give a
Yeah.
30-year bar back to 1995 regardless of, is that correct?
That's correct. And the statute.
So let me give you a scenario. You have someone that's convicted of second-degree murder, and they've been in prison 20 years. Would they be restored after being out only 10 years, even on a murder charge?
Like if they petitioned?
No, it says does not apply to convictions prior to 1995.
I understand what you're saying, Your Honor. I'll be honest, I don't know the answer to that question without having to do the research. I would suspect.
It does, plain text of the statute says it does not apply to convictions prior to 1995.
Sure. So anyone after 1995, it applies to.
But the conviction was prior to that date, even a second-degree murder, where they've been in prison for 20 years, they would, under your logic, be entitled to have the weapon.
I'm not necessarily sure that's true, Your Honor, because this statute, although the current version is of more recent vintage, I think it was last amended maybe in 2004, this statute has been around in North Carolina, I think, since the 70s. And it's actually an interesting thing because when this statute was enacted, I believe it was limited to certain violent criminals, right? And it was, you were allowed to possess the gun in your home no matter what. and it excluded long guns. And it's only through sort of this erosion of the Second Amendment right over the last maybe 50, 60 years, where legislatures have felt empowered to constrict and constrict and constrict, to where now Mr. Ducker, who has no violent felony convictions, cannot carry a gun even in his own home. He can't carry a gun lawfully in a holster, open carry, like any other citizen in this state can do. That seems problematic to me, despite the fact that everyone convicted of a felony before 1995 is sort of home safe. And as to whether that person coming out from a second-degree murder conviction that was committed in the early 90s, whether that person would have a right to a firearm, my guess is that they wouldn't, because some older statute would be applicable, or even if the newer statute is applicable, they're a felon. They can't have a gun. That's a present tense restriction that I'd have to look at the statute, the effective dates, but I'm not sure that there's a temporal limitation there.
There have been several changes to when a person can have rights restored too. And that's kind of been an evolving target over the years too.
Yes, and my understanding though is that it's a 20-year time horizon.
That's the present.
I believe that is the present, yes. It's a 20-year time horizon. And also, I don't know, I would have to look at the statute a little closer. That may be a discretionary decision on the part of a trial judge, where a trial judge has discretion to say yea or nay. And so I think that would be particularly problematic when you're conditioning the exercise of a constitutional right on sort of a judge's discretion. Typically, we don't give judges the discretion to determine the contours of constitutional rights. They're questions of law, reviewed de novo fully. And there's a legal answer. I'm about to eat into my 5 minutes, I think, so unless the board has questions at this juncture, I will yield the balance of my time.
Okay.
Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Ryan Park from the North Carolina Department of Justice on behalf of the state. North Carolina is among 38 states that has made a legislative policy determination that those convicted of felonies pose a risk to public safety if they're allowed to generally own and possess firearms. Now, there are a host of fascinating legal issues raised by this case, some of which we've already discussed today. But unfortunately for defendant, none of those issues are novel. This court's own precedent forecloses all of the constitutional arguments that defendant has made, and for that reason, the state asks this court to affirm. Now, first and foremost is a case that we didn't discuss earlier today, which is this court's Fernandez decision from 2017. In that case, this court categorically rejected Second Amendment challenges to the state's felon in possession law. And I quote, it held, conviction of felony necessarily removes one from the class of law-abiding responsible citizens for purposes of the Second Amendment. And then went on to apply the rule as follows, and I quote again, defendant in this case is a convicted felon. He therefore cannot show he's a law-abiding responsible citizen or rebut the Challenge Act's presumption of lawfulness.
I guess the question there, of course, is evident, and that's, we have Bruin and Rahimi that come along after that decision. And does that change our analysis?
Yes, Your Honor, I think that the relevant question there is whether any decision of the North Carolina Supreme Court or the U.S. Supreme Court has overturned Fernandez, has reached a ruling where the holding is contrary to Fernandez. That's the in re civil penalty standard. And although much has changed in terms of the test that is applied to Second Amendment challenges, there is no holding of the Supreme Court, or state or federal, that overturns Fernandez. If anything, the Supreme Court has taken pains to again and again reassure. Those are the words of the Supreme Court. Justice Alito for the court in McDonald, for example, repeatedly uses the word reassure the public that long-standing and widespread and common sense bans on felons owning and possessing firearms are not subject to question under the court's analysis. And the reason why the court went out of its way to give those reassurances, I think we would concede at the end of the day that that was dicta, is because a lot of the critics of the Supreme Court Second Amendment test have repeatedly said, well, if you apply your test, that means that these felon and possession bans are unconstitutional as well. And it has been set forth as kind of a reductio ad absurdum implication of the Second Amendment jurisprudence. And again, the Supreme Court says, no, you're misunderstanding our test. We are not calling into question felon and possession bans. And I think a lot of the position of the defendant in this case really kind of acts like Rahimi never happened. I think a lot of these arguments are based on Bruen and not based on the clarification that 8 justices gave in Rahimi. So there are 3 clarifications that the Supreme Court gave in Rahimi. And they explicitly said courts have misunderstood Bruen. And so we're clarifying our test. First, they said that we're not looking for historical twins. The test is not whether at the founding felons were barred from owning and possessing weapons. In Rahimi, there was no historical tradition specifically of domestic abusers being disarmed. There is no historical analog that precisely matches the modern laws. But the court said that's not the test. It's whether the historical principles underlying the founding generation's understanding of the Second Amendment are consistent with modern regulations. And the historical principle that the court identified in Rahimi was that dangerous people can be disarmed. That was the level of generality that the court established there. And they said, well, there's 2 historical analogs, only 2, that they cited to show an understanding among the framers that dangerous people can be disarmed and domestic abusers count. One is the surety laws, and one was the going armed afraid laws. Now, those again were not specifically trained on domestic abusers, but it was just a general category of dangerous people.
Let me ask you this,
yes.
do you agree that the Fernandez decision is a per se disqualification?
That is how we read Fernandez, yes.
Okay, and how, in light of the Rahimi and the Bruen precedents, that's opened the window somewhat, how can Hernandez stand per se? Your felon, no. How can that now stand in light of what the Supreme Court has given in those 2 cases?
If I could respond in 2 parts. One, so just on the facial challenge, I think, to cordon that off, as Your Honor emphasized, I think no court has found any of these 38 state laws or the federal government's laws facially unconstitutional, and that really is an untenable position, as the Fourth Circuit hypothesized. A felon who attempted to assassinate the president or murdered someone with a firearm, the legislature, of course, can disarm that person. And so now we're really talking about the as-applied challenge, and I think that it is fair to accept the premise that the U.S. Supreme Court is going to have to sort this out at some point. But the in re civil penalty test is not whether the doctrine is in flux or whether or anticipating what a higher court might do in the future. It's whether this court's precedent has been overturned. And although there might be some uncertainty as to whether Fernandez might end up carrying the day if there is a Supreme Court case down the line, it hasn't been overturned. If anything, the court has been trying to give reassurances to the public that it's not calling into question these kinds of ends. I think the other point I make on the founding era history and tradition that we know in this context is it's really a matter of not any dispute. The Supreme Court has mentioned this in the Eighth Amendment context, for example, the U.S. Supreme Court, that the standard punishment for a felony at the founding was death. That was the standard punishment. And so it's really no surprise that there aren't specific laws disarming felons when felons were executed, including for nonviolent crimes, for theft, for perjury, for forgery, and for crimes like arson, all of which, depending on the circumstances, are classified as nonviolent offenses under North Carolina's rights restoration statute. And so if the standard punishment is death, of course, they didn't have other laws disarming them. And this really goes to the second misunderstanding on the Rahimi test. So Rahimi said that we embrace the kind of greater includes the lesser principle in this context. It's not in every context, but in the Second Amendment context, we do. And so for going armed afraid laws, the court said, well, at the founding, you could be imprisoned for going armed and for causing public disturbances with weapons. And so, of course, the founding generation understood that at the founding, the Second Amendment didn't bar the lesser sanction of disarmament. And the same is true here with far greater force. If a non-violent felon at the founding could be executed, of course, the framing generation didn't think that the Second Amendment barred the far lesser punishment of disarmament. And the third misunderstanding, again, is this reaffirmation that categorical exclusions are permissible under the Second Amendment. And of course, Rahimi was a facial challenge. And the two specific categorical exclusions that the court wanted to reassure the public were not being subject to question were bans on felons owning and possessing firearms and bans on the mentally ill from owning and possessing firearms.
But how do you reconcile the circuits then that have adopted the position of the defendant?
So I think it's possible to read Rahimi as including having a silver of light for as-applied challenges, as Your Honor mentioned. The Gorsuch concurrence is instructive there. But I will hasten to note that there is only one case that anyone has been able to find where a court has actually afforded as-applied relief, and that's in Range. And the circumstances of Range are pretty similar to the circumstances in which our state appellate courts have afforded as-applied relief. The Basden and the Britt cases are the only two cases that anyone's been able to find. And in Range, it was a 30-year-old Pennsylvania misdemeanor conviction that for federal purposes counted as a felony because theoretically we could have been in prison for 5 years even though the plaintiff there was not. And there was no indication whatsoever in that 30-year period that Mr. Range posed a risk of danger. And in here, if we could talk about Mr. Ducker's criminal history. So the felony itself, he pled guilty to attempting to flee a law enforcement officer while intoxicated. So this is on record page 51. He was also pled guilty to a DWI at the same sitting. And in excess of 50 miles an hour, recklessly. Now, conduct like that is not like food stamp fraud. It creates a danger to public safety and a danger to law enforcement officers. And since that time, he has been subject to a domestic violence protective order. And I take the point that you can violate an order with conduct that doesn't independently violate the law. But you can't have an order entered against you under Chapter 50B unless a court makes a determination that you pose a credible threat to an intimate partner. And so the imposition of the domestic violence protective order is meaningful here. And this court in Basden itself said it found relevant in affording relief in that case that the individual there had not been subject to a DVPO.
So in terms of these as-applied challenges, do we need further fact finding? Do we need sort of individualized fact determinations as to whether the felon in possession statute should be enforced as against a particular defendant?
Yes, Your Honor. I mean, I've been frustrated myself at the parse factual record here, but I think there's two aspects of that I think are relevant. So one is this court in Buddington held and reaffirmed in Basden and other cases that it's the defendant's burden, at least for the as-applied challenge under the state constitution, to present facts showing that he's entitled to have his rights restored. It's not the state's burden to refute the presumption that felony status allows for disarmament. And so to the extent that there's an absence of the factual record, that favors the state. I think at the very most, if this court decides that under the federal constitution, the burden should shift onto the state, which of course we resist. It's a matter of public record that defendant has been convicted of a violent misdemeanor in the intervening time. If you look it up on the DPS website, it was an assault affray conviction. This was referenced elliptically as a class 2 misdemeanor in defendant's brief. It's also elliptically referenced in the record on page 51 of other criminal acts. That's outside the record, and so I think the very, very, very most that we think that this court could possibly afford in terms of as-applied relief would be a remand for these kinds of factual determinations to be made. What were the circumstances of the multiple DVPOs that were entered against Mr. Ducker? Did it involve conduct that suggests that he poses a risk to public safety? What were the circumstances of his particular underlying crime? Did the fact that he was driving recklessly while intoxicated, fleeing a law enforcement officer, did that create the kind of public danger that would suggest that it was rational for the legislature to disarm him? So I think that's the very most that we would concede about.
You mentioned earlier the analogy to the death penalty cases, and this court has had first-degree murder, life without parole cases come before you for defendants who were under 18 when the crime was committed. And by our precedent, we should have upheld that life without parole. even though the U.S. Supreme Court had overturned, not by name, but it said if you're under 18, you've got to have life with parole. So how can you square that we're still bound by the U.S. Supreme Court and what they say, even if they have not expressly overturned one of our state cases? So I go back to the question, if Fernandez is per se felon, no, and now you have U.S. Supreme Court precedent that says no but, aren't we bound by that but and say, okay, Fernandez no longer on a per se denial is good law?
Well, Your Honor, I accept the premise very much that if there is a controlling Supreme Court, U.S. Supreme Court, North Carolina Supreme Court decision that's inconsistent with this court's precedent, then this court, under vertical judicial decision-making, has to follow that higher.
Notwithstanding the prior decision to the contrary.
Yes, Your Honor. But I think if we have any information from the U.S. Supreme Court, it's the justices, 8 justices in Rahimi, signing on to an opinion that says we're going to go out of our way, even though it's not an issue in this case, to say long-standing and widespread bans on felons owning firearms and possessing firearms remain presumptively valid. So that's the extra information that we have here. And I think given that context, Fernandez should stand. One other factual aspect of North Carolina's process that I think is relevant to the decision-making here is it's not a permanent ban. There's a 10-year process. After 10 years, Mr. Ducker would have been eligible to seek expungement of his felony, given how it was classified, had he not engaged in additional criminal conduct, including the assault, which is in the record, and the domestic violence protective order violations. And after 20 years, he could have sought specifically his rights restoration under the statute. I think the Supreme Court grappled with this a little bit in Rahimi in terms of the duration of the violation. The defendant in Rahimi said, well, there's some states where if you're found to have posed a credible risk of spousal abuse, then you're permanently disarmed, and that's a problem. But the court said, well, in this case, it's 1 or 2 years, and that's sufficient. But I think that, given a system where for a non-violent felony, if you keep your nose clean for 10 years, you're eligible to have your rights restored, I think that's meaningful here. This court, and again, the only 2 times where it has afforded as-applied relief, it involves situations where it wasn't a criminal defendant coming to the court and saying, I know that I violated the law, but it's unconstitutional. It was someone who voluntarily disarmed, went to a sheriff's office and said, you know what, I think that it's not proper for me to be disarmed. I'm going to hire a lawyer and bring an affirmative lawsuit to try to have my rights restored. And then the legislature created a formal process for rights restoration so it wouldn't be such a burden in terms of procedures.
Would the conviction of any misdemeanor within the first 10-year period bar relief?
I don't believe it's any misdemeanor, Your Honor. I have the statute there, but there's a list of disqualifiers. And so if you commit a violent crime or a felony that is above a certain classification, then you are not eligible to have your rights restored or to seek expungement of your nonviolent felony. I know it hasn't come up yet so far, but I would like to speak a little bit about the cert petition that was filed on the attempt issue. So just 3 quick points there. So one, I think this court would be clearly within its discretion to deny the petition outright on timeliness grounds. Previous panels have denied petitions where the delay was less than a year, and here it was a little bit more than a year. But if the court does reach the merits,
We'll often reach cert petitions that are just simply filed contemporaneously with the regular appellate process.
I grant that, and I think it's truly within the court's discretion. The rule sets an unreasonable timeliness standard, and so our position is the court can do that. It would not be an abuse of discretion for the court to do so. But on the merits, Your Honor, the statute sets up a framework where you violate it if you're fleeing or attempting to elude a law enforcement officer. I grant that this statute could be drafted more clearly, but the standard that this court, that actually the North Carolina Supreme Court established in Floyd, isn't, well, is there some amount of overlap between these two definitions? It's, can the statute, or can the common law offense in that case, be read where there is no overlap, even if there is significant overlap in many circumstances? And I think that the definitions of flee and elude that I guess petitioner in this situation advances in his brief show that there is a distinction between the terms. So he cites dictionary definitions that flee means to run away, so in this context means to drive away, whereas elude means to escape adroitly, which suggests that elude requires some element of deception or subterfuge. And of course there are ways where you can escape detection. You can elude a law enforcement officer without fleeing. The district attorney below suggested a situation where at night you turn off your lights in your car and you lean back to elude detection. And that's all that Floyd requires, is that there is some way for the offense to be read and established in a way that doesn't create an attempt problem. I would also like to highlight Justice Newby's concurrence in Floyd, where he suggests, well, where he points out it's a very similar situation where someone is trying to defeat a felon in possession charge by collaterally attacking the underlying felony. It's not a real crime. And what he says, well, the defendant in that case, like here, pled guilty, admitted to the criminal conduct, and should not be able to exploit the benefit of his own deal. He received a lesser sentence based on his admission of guilt to a particular crime. And in that context, doesn't mean that his challenge categorically fails. It means we're not going to look at the circumstances of his particular crime and say, was it an attempt, or did he actually commit the underlying crime and he just pled to an attempt? What we're going to ask is it theoretically possible to charge the statute and plead guilty to it without creating an attempt?
Yeah, and is it not significant that here the attempt was sort of written in on a bill of information, right? He was charged by information, and then subsequently pled guilty. We don't really have the prior history of what might have the prior charging documents there, I guess.
That's right, Your Honor. That's right, Your Honor. And I think Floyd establishes that it's not a factual inquiry into whether he actually fled or he attempted to fled. It's whether the court had jurisdiction to accept a guilty plea for attempting to flee. And because there are a variety of situations where you can attempt to flee without attempting to elude, then I think the court had jurisdiction to accept it. I'm happy to turn back to the constitutional questions if the court has further questions. If not, I'm happy.
Well, I guess I have one further question on that front. You do identify what the state would contend are two sort of North Carolina specific analogs justifying the statute, but are we limited to considering those two analogs proffered by the state, or are we permitted to sort of cast a wider net? And do you contend there are other analogs specifically that at which we should be looking?
Yes, Your Honor. I think that you're looking on, in doing the federal constitutional analysis, you're looking at what the framing generation as a whole, not just the North Carolina framers, but the framers as a whole believed to be the scope of the Second Amendment guarantee. And so, yes, I think you look at analogs across the original 13 states. And here, I mean, we don't have to go any further than Rahimi itself. The court establishes this how and why standard. So you have to look at how the framing generation understood it was the government could disarm individuals and why it did so. And here we have a pretty similar how and why. The why is simply that dangerous persons. The legislature can determine that there are categories of persons who pose a risk to public safety if they're given access to firearms. And felons fall into that category, domestic abusers fall in that category, the mentally ill fall into that category. And the how is disarmament, and it's similar in both cases. And I think our strongest argument there is what I mentioned below, which is this greater includes the lesser principle. So, the going armed laws at the founding, the sanction was imprisonment. And again, you're not saying, well, was the sanction disarmament, and therefore were there specific laws that disarmed domestic abusers? It's, well, if the founding generation thought it was permissible to imprison people for going armed and giving a threat of public violence, then they must have thought it was also permissible to disarm them. And the same is true here, much more markedly so. Because again, standard punishment at the framing, it seems antiquated now, was death, even for nonviolent felonies. And so the state would submit that the framing generation understood that if you could execute someone for committing a nonviolent felony, then surely you could impose a disarmament.
The going armed to the terror of the public, that statute, merely being armed in public does not violate that statute. Do you agree with that?
That's correct.
So there'd have to be something more than just being armed and being in a public space.
Yes, Your Honor, and I think, the U.S. Supreme Court actually, Rahimi, discussed extensively our state Supreme Court's decision in Huntley, and where the court gave reassurances that, we're not saying that the mere public possession of a weapon means that you're committing a criminal offense. In that case, it was a misdemeanor. But it's if you go armed with an evil and wicked intent, and then that suggests that you are causing terror to the public, and you may be disarmed. But of course, again, Rahimi didn't involve a going armed offense. It involved a domestic violence restraining order. And so they're very different offenses. And so the state's general submission is that you can't look at that level of granularity. That's the mistake that Rahimi, 8 justices, tried to correct lower courts from making. You look at the specific offense and say, are there dead ringers, is what they call them, are there historical twins, where this specific law was passed by the North Carolina General Assembly in the 18th century. That's not the test. It's whether, based on what they did pass, what do we think the framers would have thought that the law before the court today was constitutional? And I think I would also recommend to the court the Justice Barrett's concurrence in Rahimi, because I think that's very, very telling. Justice Barrett said this is just bad original to say that if the legislatures didn't pass a certain law at the founding era, then current legislatures can't pass any other law other than those. That's not how originalism works. You're trying to understand the general scope of how people during this time understood the Second Amendment or any other constitutional right. And the way she put it is, it's a categorical mistake to think that early legislatures always legislated to the maximum of their legislative authority. That's not how it works now, and that's not how it worked at the founding. No further questions? I think I would close on this. I would ask the court to examine the record that the court has before it. Again, it is limited, but on record page 51, it's pretty unambiguous that the defendant here, his underlying felony put the public and law enforcement officers at risk. He was intoxicated while he recklessly fled from a law enforcement officer at high speeds. And since that time has engaged in other criminal conduct that suggests that the legislature could rationally view him as someone who could be subject to disarmament. And the domestic violence protective order, well, that was at issue in Rahimi itself. And I think that's pretty good evidence that the as-applied challenge here should fail as well. Thank you.
All right, thank you very much. All right, rebuttal.
Thank you, Your Honors. Briefly here, the state mentioned in its argument something about my client having an affray conviction and pointed to page 51. This is news to me. It's not anywhere in the record, and I'd ask for the court to strike that. And even if he were convicted of an affray conviction at some point in the recent past, the simple affray has nothing to do with firearms. This offense has nothing to do with firearms. The state is erecting a straw man display in this case. Nobody is arguing that originalism is a regulatory straitjacket. It is not. But it's not a regulatory blank check. And what the state wants in this case is to have a regime that is status quo. We simply say, because you have been convicted of a felony, you do not get to have a gun under any circumstances. And that is not supported at all by the historical tradition of this country. Not at all. If the state actually looks at the historical record that has been laid out. Zaki Rahimi, in the Rahimi case, I'm pretty sure was a felon. Why is there all this discussion about whether or not DDPO orders in the modern era are similar to armed going to the terror of the public or surety laws and this historical? They could have just said Zaki Rahimi's a felon. He doesn't get that wrong. It is not as simple as the state is making it out to be. And in fact, I think it is the state that is doing the bad originalism here. Right? This is malicious compliance originalism. This is just such an unworkable test. We can't do it. Courts are going to have to throw up their hand. No, this is very workable. Right? We need to have a regime whereby the dangerousness of a person is the critical focus of the legislative regime. We don't have that system now. We don't have that. If that system existed at one point, it's been now cabined and cabined and cabined to where even someone like Mr. Ducker cannot possess a firearm even in his own home. The Second Amendment doesn't allow for that if you actually perform the analysis required in the court in this case. We're not looking for historical twins, we're looking for historical analogs, something that looks and feels a lot like what we have in this case. I understand that felony was a term of art at the founding that it compelled the death sentence, and so there may be not laws about whether we can dispossess felons, qua felons. We don't have any laws until the 20th century that even suggest that the government can tell someone, because they've been convicted of some crime, that they permanently and continuously cannot have a gun for the rest of their life, which is essentially the system we have now, barring the 20-year restoration of firearm rights situation. The holding of Rahimi is not that dangerous people can be disarmed. That is not the holding. Rahimi says the particular domestic violence protection order prohibition in the federal statute was sufficiently similar to historical analogs. It did not say, well, dangerous people can be disarmed and so we therefore don't have a First Amendment problem. In fact, in Rahimi, when the court is looking at the arguments of the government in that case, it specifically rejects the argument that the government can just designate certain classifications of people as not responsible. And I think that the dangerousness label that the state is leaning so heavily on is really not a whole lot different than the not responsible label. There's got to be some meat on the bones. There's got to be pointing to something in the historical record that shows that our conception of this right at the founding included the ability of the government to come in and permanently disarm someone merely for having committed some criminal offense in the past. We have nothing that even looks slightly like that until the 20th century.
On your as-applied challenge, would you respond to the state's argument on what I understand was the guilty plea, an admission, and then the conduct of being intoxicated, traveling at high speed, reckless, fleeing from officers, whether or not that type of conduct would satisfy the dangerousness statute? Or condition.
No, I don't see how, even if you accept the worst possible version of what this crime could conceptually be, which I'll agree with the state we don't have in the record, and the state faults, I think, the defendant in this case for not building the record. Maybe we should have hired a lawyer to go and prosecute this claim prospectively in the form of a declaratory judgment action. The reality is that most defendants are not going to have that privilege to be able to do that. So this is going to come up in criminal cases with limited records.
So the absence of the record is probably due to the fact the client pled guilty, right?
To that offense 15 years ago, yes, Your Honor. And we don't know. Indictments and information is certainly not evidence. Indictment certainly isn't. And there was a guilty plea to a crime that we don't even know if it exists or not. This court will have to answer that question. But whether or not this is even a crime in North Carolina is in question in this case. We're talking about whether we can dispossess this man of his firearm rights for the rest of his life on the basis of that conviction. I don't think the U.S. Supreme Court precedent would allow this court to do that.
No, you said the rest of his life. He would have had a right to restore if he had been a law-abiding citizen, right?
After 20 years, a judge may have had a discretionary decision to make as to whether or not he could have his firearm rights.
Right.
Which yes, Your Honor. Mr. Ducker is 50-something years old and is effectively the rest of his life. I will conclude here just by saying that you know, something like 1 in 12 Americans have a firearm conviction. And to paraphrase the court Rahimi, the Second Amendment neither excuses a regulatory blank check nor mandates a regulatory straight check. Surely there is some legislative regime that we as a people could create that would dispossess dangerous people of guns, sort of like Rahimi, upon a showing of dangerousness for some limited time, of a certain class of violent criminal. Surely the General Assembly could enact a regime that looks like that, and it would probably sustain constitutional muster. To suggest otherwise would be an error in favor of the regulatory straitjacket. But the historical evidence is that our modern legislative consensus is not deeply rooted. It emerges in the 20th century, long after these questions have been hashed out at the founding, long after they've been hashed out with incorporation with the 14th Amendment in the 1860s. There is no evidence of presumptive, preemptive, permanent, and indiscriminate disarmament of criminals, of people convicted of crimes in this country. And the statute in this case is merely a creature of the time where legislatures gave courts gave legislatures rather a regulatory blank check. And after Bruin, that time is behind us. So this court must reverse because a minimum application of the statute is unconstitutional in this case. Apply it to Mr. Tucker, and I'm happy to take any questions the board may have. Otherwise, we would thank the board for its time.
All right. Anything else?
Thank you very much.
All right, thank you very much. And let's see, we will, I guess, officially adjourn this session, and then we're going to just stay for a few minutes and answer some
The
questions.
session of North Carolina Court of Appeals is now adjourned.
Now we're officially adjourned. Do we have some, do we have some students here, I hope? Any students? Okay, because, we're here to educate y'all, so, so, I don't know, let's see. I guess the other session is supposed to start, so I guess we have a lot of time. Anyway, we were just, I know, so we only have a couple students? All right. Okay. Well, all right. Well, we brought some people to the court. Apparently, we brought a lot of people to the court. So anyway, I don't know. What are y'all doing?
But I'd like to thank those of you who came, and are there any questions of counsel that any of the students would have, or any questions directed to the court about, we can't tell you, of course, how the court's going to rule, because we don't know ourselves probably yet. So, but are there any questions, counsel, about anything that you've heard that you'd like to ask? We come to law schools for a learning experience, and so we'd like to make sure anyone has an opportunity to raise a question if they have a question. Yes, Gary.
So this case kind of centers on how we interpret this legislation through the context of originalism. But as you guys know from reading cases, there's many kind of different flavors that we've seen from like Scalia, Clarence, or Justice Scalia, Justice Clarence. So do you guys have a preference of how, of like which flavor you find particularly meaningful or like persuasive?
That was probably a little too specific on this case. Because we can't talk about this case, so I'm not sure. So that's a good question, but I'm not sure that we can really get into that given the context of this particular case. So anything general?
I think the short answer to that would be that even in the context of textualism or originalism, there's probably not just one way to look at that. That would kind of be the broad answer, that textualism and originalism are not monolithic.
No, that's true.
Thank you.
All right. Anything else?
I'd like to introduce some guests that are here, if that's
Okay,
okay.
sure.
I have our chamber staff that's with me today. Christine Nunn is my executive assistant. I have my resident from Elon Law School, Dimitri, that is here. I also have the distinct pleasure of having my wife Kirby here today, and two of her staff members, Emily and Elizabeth. And we have a guest here today from Israel, whose name is Israel Stefanski. So we welcome him back to the court as well, and thank you all for coming and being here today. Some folks.
Well, I brought one of my clerks. Matt Ferris is back here somewhere. He went to Elon, but we will forgive him for that. And so that's the only person I brought today.
Well, I have my law clerks, Chris Castor-Rappel, Kate Spangler, and Kelsey Kennedy. My Elon resident, Adam, was here, but I know he's run out for class. And then my intern from UNC, Rebecca Jackson.
All right. Well, I guess since the other panel is waiting to come in here and do an argument, we will go ahead and head out. And for anyone, I think there's going to be a reception after the next argument. So if anyone can hang around, that would be great. You're welcome to do that.
All rise, please.